Good afternoon, ladies and gentlemen. Thank you for spending your time to be with us this afternoon. On behalf of Namma Bengaluru Foundation, at the outset, first, I would like to thank the panelists on the days, the distinguished panelists for being here and providing the motivation and support and guidance to the citizens that's so sorely lacking today. A special word of thanks in advance to Namma Bengaluru Foundation and Shri Rajeev Chandrasekhar for organizing this event to expose the citizens to the various issues involved in the RERA bill, which Rajeev played such an important role in piloting and pushing through. It's my pleasant duty to introduce and welcome some of the distinguished panel members on the days today. I start with Justice A.V. Chandrasekhar. Justice A.V. Chandrasekhar is a former senior justice of the Karnataka High Court, a public-spirited judge who's been involved and handled several crucial cases in his long legal career. He has a reputation on the bench as being a highly intellectual judge and highly sharp in handling cases, and enjoyed the confidence of the entire advocate fraternity in Bangalore during his legal career. Welcome, sir. It's also my pleasant duty to welcome Shri Sajan Povaya. Sajan is a former additional advocate general for the state of Karnataka and designated senior advocate. He practices in both the High Court and the Supreme Court of India. In addition to an extremely busy corporate practice, Sajan still manages to find the time, I don't know how, to appear in various public causes from time to time, and has been an invaluable asset and ally of citizen groups in their legal fights in various public-spirited causes. One prime example of Sajan's involvement in such cases was the recent National Green Tribunal order relating to protection of wetlands, which we will be hearing about in due course. Welcome, Sajan. It's my pleasant duty also to welcome Shri Sunil Dutt Yadav. Sunil is a fellow Koromangalite. He also lives a few streets away from me in Koramangala. But more important than that, Sunil has been an advocate in the High Court for over 2 decades. He's an alumnus of the National Law School of India University in Bangalore. He is part of the ESG legal team and has therefore appeared in several high-profile environmental cases over the last few years. Recently, Sunil has been named as special counsel to represent the state of Karnataka in matters relating to the Nandi Infrastructure Corridor project, both in the High Court and the Supreme Court. Welcome, Sunil. Okay. It's my pleasant duty also to welcome Professor Rajagopalan. Professor Rajagopalan is a citizen activist. He's a member of the L&T South City Apartment Association. He's a fellow from the Indian Institute of Management, Ahmedabad. Professor Rajagopalan is an academician and a former professor of the Institute of Rural Management, Ahmedabad, for over 25 years. And he's also served as Dean of the TA Pi Management Institute, TAPME, for several years. Welcome, Professor Rajagopalan. And last, but certainly not the least, is Rajeev Chandrasekhar, Member of Parliament from the Rajya Sabha, a person who actually needs no introduction, but I would say that Rajeev has completed 10 years in public life, and it has been a very, very engaged 10 years in public life. He has used his years in public office to mount strong advocacy for the rights of citizen groups all over Bangalore city. Whenever citizen groups need a champion to champion their causes, they have no stronger champion than Rajeev Chandrasekhar. Welcome. Thank you, Rajeev. Having welcomed my panelists, I would like to also welcome several associations who have come here today with representatives. I would like to welcome the representatives from BRACE. From the Citizens Action Forum, we have representatives here. From Civic, we have representatives from HSR Layout Residents Welfare Associations, from Apartment Adda, and a whole bunch of other residents welfare associations which I see represented here today. Welcome all of you, and thank you so much for making time on a Saturday afternoon and coming here all the way to attend here today. And welcome to citizens of Bangalore and the media who are here in strength today to cover this event. I would now like to request bouquets to be handed over on behalf of Namma Bengaluru Foundation to the various dignitaries on the dais today. I would first like to request Sridhar Pabishetty, the CEO of Namma Bengaluru Foundation, to hand over a bouquet of appreciation to Justice Chandrasekhar. Thank you, sir. I would next like to call upon Shri M.S. Shankar from the RERA Karnataka chapter to hand over a bouquet to Shri Sajan Povaya on behalf of NBF. Okay. Next, I would like to call upon Shri George Verghese, President of the Horamavu RWA, to hand over a bouquet to Shri Sunil Dutt Yadav. May I request Shri R.C. Dutt, the President of the Federation of Sanjay Nagar RWAs, to hand over a bouquet to Professor Rajagopal on behalf of NBF. Next, it's my pleasant duty to request Shri D.S. Rajshekhar, President of Citizens Action Forum, to hand over a bouquet in appreciation to Shri Rajeev Chandrasekhar. It is my pleasant task to request now Shri Chandrasekhar, Justice Chandrasekhar, to make his opening remarks on this august occasion. Justice, sir.
Shri Rajeev Chandrasekhar, Member of Parliament and President of Namma Bengaluru, Mr. Sajan Povaya, Mr. Sunil Dutt Yadav, learned advocates, Mr. Rajagopal, Mr. Nitin Sheshadri, and distinguished participants in this workshop. All of us know the difference between a seminar and a workshop. Workshop is always intended to know the provisions of a particular statute or an aspect and the implementation part thereof. Seminar is one where we will discuss various issues relating to the intention. Now the intention is clear. Act has come into force. Act has come into force in its entirety according to me. How to implement it and how to reap the benefits by the stakeholders enumerated in the Act. Friends, when Mr. Rajeev Chandrasekhar came here, first question of mine was to him, who was the man behind this? He said, sir, it was, this bill was introduced during UPA regime, but subsequently, lot of changes were made, and he was in the select committee, and a lot of debate took place, right from the fact as to whether it would come under the concurrent list or the state list, and ultimately on the opinion of the Attorney General, it is treated as a concurrent list, and the Act has come into force. Friends, I had an opportunity to go through the materials supplied by Mr. Sridhar. It is according to me, it is a most comprehensive and effective and a powerful act. That act has provided for everything. The lawmakers have visualized even the smallest things and have provided for the same. Normally, what happens is, before an authority as contemplated under the act is established, nothing will move forward. But in the present act, there is a provision till the establishment of the real estate authority and the appellate tribunal, somebody need to be appointed by way of a notification by the appropriate government. I don't know whether Karnataka government has appointed the Principal Secretary, Department of Housing and Urban Development as the regulatory authority. 1 year time is given. 1 year, see, this has come into force on 26/3/2016, the day on which it was officially gazetted in the Extraordinary Gazette of the Government of India. So 1 year time is granted, but for establishment of a real estate regulatory authority, till such establishment, the government by notification is expected to. Probably they might not have seen it. The organizers may bring it to the notice of the law secretary, who is basically a judicial officer there in the government, and he would take up the matter with the concerned, and I think suitable notification would come. The second is the appellate tribunal. It's a tribunal which sits in appeal over the orders of the regulatory authority. So there is no appellate tribunal. So some tribunal which has the force of law will have to be clothed with powers. For example, we have Karnataka Administrative Tribunal, which deals with service matters of state employees. And also we have Karnataka Appellate Tribunal, which is headed by a bureaucrat of the cadre of an additional chief secretary, and also with some judicial officers working there as members. So it is left to the government's decision to clothe the powers with the authorities they deem it fit. And I think the organizers can take up these issues with the concerned government. Friends, first of all, we will have to see the preamble of the act. Whenever we read an act, normally we forget to read the preamble. But first of all, as judges and as advocates, our duty is to read the preamble first. Normally, only in Constitution, the preamble gives some important clue. While interpreting the provisions of a statute, it is said that the preamble of a particular statute will not be of much importance, but anyhow it has some importance. We can't undermine the importance of the preamble. What is the preamble? I will just read it. An act to establish the real estate regulatory authority for regulation and promotion of the real estate sector and to ensure sale of plot, apartment or building, as the case may be, or sale of real estate project in an efficient and transparent manner, and to protect the interest of consumers in the real estate sector, and to establish an adjudicating mechanism for speedy dispute redressal, and also to establish the appellate tribunal to hear appeals from the decisions, directions or orders of the real estate regulatory authority and the adjudicating officer and the matters connected therewith or incidental thereto. If you read the preamble as a whole, it may appear that this is basically intended to protect the interest of the buyers. Okay, it is there. But at the same time, it also protects the interest of bona fide promoters also. What it wants is the real estate should develop in India because people want shelter. So there must be some regulation. Why regulation is required? There are some unhealthy practices. Give up those unhealthy practices. There are persons who cannot invest too much of money to have a small shelter. So since such people are large in number and promoters need to be regulated to a little extent. And one important aspect is when a dispute comes between a promoter and an allottee, see there is a provision is there for offences, taking cognizance, trial of such offences by courts on a complaint by an authority, prescribed authority or any person authorized by the authority. But at the same time they are compoundable. They are compoundable because they want the matter to be smoothly settled also. Friends, so many provisions are there for registration of the real estate agent, real estate project. Only one thing I would like to know, as Mr. Rajeev Chandrasekhar had deliberated extensively. See, the Act is not applicable. There is an exemption of the provisions of the Act to an area measuring about 500 square meters. It would be somewhere about 8,470 square feet. My apprehension is that, so somebody may even take up small constructions within 8,470 square meters and get away with the rigor of the Act also. And there are 8 floors, 8 flats. So there should be a discussion on this aspect also, whether this exemption would really come in the way of the interest of the honest and bona fide purchasers. And one more thing is, I'm more worried in respect of purchasers. Because if you go to a financial institution or a bank, after the coming into force of the Act, they want everything to be complied strictly, and then only the finance will be released. It will be very difficult also. So please keep the interest of the purchasers in mind vis-a-vis the bank's role to be played. I think we have 2 wonderful lawyers, Mr. Sajan Puvaya, senior advocate, and Mr. Sunil Dutt Yadav. Both of them are from law school, very knowledgeable and very well-meaning advocates. Mr. Raj Gopal is basically a man in the management field. He has spent sufficient time in teaching and management. And we have Mr. Chandrasekhar, who has an extensive experience of 10 years as a senior member in the Rajya Sabha. We have elite members of the citizenry to take this act into its logical end. With these words, I throw open the discussion for the session for a meaningful discussion. Thank you.
Yeah. Thank you, Justice Chandrasekhar, for giving us a clear perspective on the RERA Act and the implications for all of us. As you rightfully pointed out, sir, a few issues relating to implementation need to be addressed, especially by the state government. And as you rightly put it, this act protects both genuine buyers and bona fide real estate developers as well. Thank you. Before we get to the open house, we just have a few more remarks by the panelist members. It is my pleasant duty to request Professor Rajagopalan to give us some perspective as an activist and as a potential home buyer on what RERA means to an activist and home buyer. Professor Rajagopalan.
Good evening. I would, given the galaxy of legal experts here, I started reading law only after buying my apartment. So whatever knowledge I have of law is from reading that. And okay, I would leave the Real Estate Regulatory Act because on the whole, after going through it, I find it's a very good act, except for 2 points, which I would like some knowledge from this panel. One is, in our experience, I find it's okay. See, I am just wanted to point out 2 things in the real estate bill, which I think needs elaboration for our benefit. From our experience, we find that unless there is a provision for action against colluding approval authorities, things are not going to be easy. There is nothing in the act which talks about that. Second is, there is a talk about necessity for title insurance. It is not very clear to me how the day-to-day problems of buyers will be solved by having title insurance. There has to be some system, either in the registrar's office or wherever, where they can check at least that the person who is transferring the property has a good title, at least in their records. In the past, we have had several interactions without much success. Within that, I would just highlight a few points. from my experience as a fellow sufferer rather than a buyer, I have personally gone from the local police station right up to the Supreme Court, Competition Commission of India, High Court, Civil Court, Criminal Court, Consumer Court, Mediation Center, you name it, I have been there, including being slapped with civil and criminal defamation cases, which I am currently fighting. Therefore, it is not easy. Implementation is not going to be easy unless we are willing to take up cudgels and stand the course. 2 or 3 aspects where foul play has made us really suffer. Incidentally, I am from South City in Banargata Road. It's a 2,000 apartment complex. The provisions in the Karnataka Ownership of Flats Act, which is the corresponding state level act as of now, does not get enforced on the ground because the builders do not form the association the moment 10 apartments are sold. They wait till the entire project is over so that there are 2,000 apartment owners. Obviously, there is not going to be unanimity among 2,000 owners, and therefore we are fighting each other rather than fighting some injustice which is being done. This is something which the Real Estate Regulatory Authority Act, understandably so, does not address. Second, this leads to delay in conveyance of the title of common property of a particular complex, which results in various problems. I am talking mostly from the perspective of apartment complexes, which seems to be the norm in metros like here rather than individual houses. Pardon me, I don't have much of a knowledge. The Karnataka Apartment Owners Association Act has a provision which has been misinterpreted and put us into a lot of trouble. It says this act is applicable to only property the sole or all the owners submit the same to the act. Now, it is virtually impossible in any apartment complex of reasonable size to get unanimity and ensure all register. We have been fighting this case in various fora, and the delays in the judicial process is such that we have been fighting for 8 years now. Still the issue is not resolved. Until that is resolved, nothing else can move forward. This is something which I would like to discuss. As far as access to information, which we have been using RTI so far, the real estate bill makes it much easier to get information, which is a great help. Delaying tactics by the builders using the law, difficulties in forming buyers groups or apartment association, which I have already talked to you about, and invariably the builders plant some Trojan horses. If there are 2,000 apartments, there will be 2-3 people who are their men who will hold an apartment, will hold you to ransom till you sign on the dotted lines. And therefore, this is something which has to be interpreted in the spirit of the law, preamble, as Justice Chandrasekhar was pointing out. And physical threats and defamation threats. For any office bearer who wants to take it up and fight, this is an ever-existing thing apart from the hassle of running after. These are the points I would like the workshop to deliberate upon. Thank you.
Thank you, Professor Rajagopalan, for raising the very pertinent issue of action against collusion by government authorities. It was very illuminating to hear from you, sir, on many of the travails of apartment buyers in our wonderful city of Bangalore. We've heard so much about RERA, but we've heard about this from a user's perspective. Now, before we get to a judicial perspective, I would like to get a perspective from the people who actually wrote this legislation. And there's no better person to bring this perspective before us than Shri Rajeev Chandrasekhar, who was one of the key people who was responsible for piloting this bill and getting this bill through the parliament. I would like to invite Rajeev to speak on this initiative and what the entire purpose and intent of this is. Over to you, Rajeev.
So thank you, Nitin. I am sorry to insert myself amongst the panelists, and I thought I should just lay some overall backdrop before we get into the details. So there are two things I just want to bring to your attention. One of the things is about why I am doing this Namma Hakku citizens' rights workshop, and I intend to do this once every 2-3 months on different subjects. And the reason is very simple. I have been now 10 years your member of parliament. And for most of those 10 years, I have struggled, attempted, prayed, fell at people's feet, begged for changing the way our city is being managed and governed. And in some cases, I've had some success, and most of those cases where I've had success have to do with courts rather than any government or political or administrative response. So one of the things I would like to convey, and I want all of us to get behind this idea, is the idea that we have rights, and there is a point in time that we have to stop begging our elected leaders and begging our administrators to do what is right for the city, and in some sense tell them it is our right to have these things done for our city, have these things followed, have the laws followed, and have cracked down on corruption. These are not things that are academic. These are things that are essentially our rights. So I want to essentially move this move for change to be less outsourced from you to me, and to be more of a collaborative approach where hundreds and thousands of us can, go and say these are our rights, and we seek to enforce them. So I just want to explain why I want Namma Hakku to become more and more as the principal platform to exert pressure, send out a message of change, send out a message of assertion of our rights as citizens. So that is number one. Number two, let me just talk about RERA and the issue of consumer rights. The origins of RERA are in the decade-old model, which has been a lopsided model where builders have essentially, the relationship between a builder and a buyer has essentially been one of exploitation. It has never been an equal relationship. So there are builders, good, bad, huge, small, whatever. And the relationship between them and the consumer has never been one of a satisfactory, balanced relationship. And so the entire onus of this bill, entire focus of this bill rather, is to create, enshrined in law, consumer rights. That is, every house buyer has a set of rights that cannot be trampled with by any builder, big, small, dubious, credible. Every builder has to recognize, just like every politician and every bureaucrat recognizes the fundamental rights of a citizen in the Constitution, it was important that this bill enshrine the fundamental rights of a home buyer or a home consumer, and that is what this bill attempts to do. Second, it holds the producer, that is the builder, accountable. The other problem, as Mr. Rajgopal was saying, was this issue of having to constantly litigate to assert your rights. You are paid for a 1,500 square feet super built area flat to be delivered in 3 years. You get something that is 1,480, delivered in 6 years, price escalated in a building that was supposed to have many facilities but does not have any. What does a consumer do? You go first to this court, then you go to another court, and that whole relationship is predicated by the assumption by a builder that he can outlast a consumer. He can out-lawyer a consumer. And that is what the bill attempts to equalize. And while the bill, and correctly, every bill and every legislation has weaknesses and lacuna and has room for improvement, it fundamentally establishes two things. Consumers have rights, builders have obligations. If the builders fail on their obligations, there are penalties. So Chapter 2, Chapter 3, Chapter 4 deal with obligations of the builder, rights of the buyer, and punishment and penalties. These three chapters, in a sense, describe what the bill does. It establishes unalienable rights for the home buyer, which cannot be trifled with or litigated with, because you cannot do, again, forum shopping. You can't go to a friendly high court or a friendly district court or some other court somewhere in the boondocks. You have to go to RERA. And if you don't go, and if you fail in RERA, you have the right to appeal in the appellate tribunal. So I just want to tell you that that is the basis of the bill. What it does, for example, now you will say, for example, conveyance, there are issues to do with local. Now there are many issues to do with local government. For example, commencement certificate. Um, but that is now going to put pressure on local governments and local municipalities to reform their own internal approval process. Because you cannot commence a project without registration. You cannot register a project without commencement certificate. So there is no question of pre-selling projects. The entire, let us say, fraud that has been committed on many, many occasions is when projects are pre-sold without approval, without due diligence, and an unfortunate consumer will end up paying in advance for a project and find that the project has not got its approval, plans approved, or the land has not been converted into a commercial or a residential utilization, and the consumer is unfortunately trapped in that project. So all of those issues are gone now. With this bill, you as a consumer get into a project that is disclosed online, with a builder whose track record is disclosed online. He can only sell you a project when the project is ready for construction. He cannot use the money that a consumer has given him. 70% of the money has to be locked up for that particular project. So it is, in a lot of ways, a big, big, big leap forward for the consumer. And I just want to anecdotally make one last point before I hand over the mic. Trust me, a lot of builders did not like this. And the amount of pressure that parliamentarians came under to dilute this and dilute this and dilute this from the biggest builder to the smallest builder was enormous. But I believe this is the first time a legislation is being put forward where we are balancing, what I said in Parliament is, I said we're redrawing the balance between the investor and the big corporate and the small consumer. And the balance is now a straight line as opposed to being like this. So what I would like is for more and more of you to be aware of the bill, use the bill, and of course, like Justice Chandrasekhar said, the government of Karnataka has to wake up and enact the RERA. It has to, in the interim, appoint a designated principal secretary to act as RERA and get the bill moving. And that is where more and more of the consumer pressure on government will also act. I will do my bit. But it is necessary for consumers to know that this bill and their pressure behind it or their push behind it is good for consumers and is good for reforming the industry. This is not anti-builder. This is pro-good builder and this is pro-consumer. For those builders who thought the business model is about scamming consumers, of course they have to look for another alternative profession. But for all those good builders who genuinely believe that consumers must be satisfied, this is a good bill. Thank you.
Thank you so much, Rajiv, for throwing light on the rationale for the RERA bill, enshrining the fundamental rights of citizens. As you rightly pointed out, in the pre-RERA era, a citizen had no recourse except to go through the court system. And many a time, buyers were forced to accept weak or ineffectual orders, which did not impose penalties in proportion to the agony that a buyer went through. That has what has changed in the post-RERA era. Thank you again, Rajiv. It is my pleasure to invite Sajan Povea to speak to the group on the rights of a citizen against developers who actually violate the law. Sajan.
Thank you, Nitin. Dignitaries, ladies and gentlemen, I'll possibly seek the indulgence of not giving a monologue in terms of what I have in mind on what the rights of a citizen is and what are the remedies that are available to him vis-a-vis countering a builder who violates the law. I think we have a debate which will emanate from two things which will be presented to you during the program. One is the order of the National Green Tribunal, which has created a huge change in the manner real estate development is perceived in the country. Second is, of course, the nuances of the Real Estate Regulation and Development Act itself. And therefore, during the question and answer sessions, I'll of course be moderating that. I'll be happy to add my perspective. But I will only say one aspect of what has changed over the last decade in the real estate scenario is that there is a convergence, if you will, of the right-meaning politicians with integrity on the one side, civil society groups on the other, and the right-meaning judges on the third. And the culmination of something like that, I think, is seen here. You know, it occurs to my mind as somebody, I'm a lawyer, I'm not a political analyst, but I kind of see what happens in the system from within and outside, having served in government at some point in time. You know, what I think somebody like Mr. Rajeev Chandrasekhar has achieved by virtue of the NGT order in terms of creating that whole spark in the powder cake is possibly more than what an entire government could possibly achieve over 5 years, and you will see that. The second aspect is that when it culminates into a legislation, and it is still not the case that, you know, our politicians don't stand up for us. We still have a small part of that tribe, you know, which includes Mr. Chandrasekhar, who stand up for these rights. And when you look at that, and if you look at the statute, the one thing that has bothered me as a lawyer, and let alone as a litigant, which has bothered me as a lawyer, is how would somebody who has bought a 2-bedroom apartment and has faced a series of issues land up paying this multitude of lawyers to go before the consumer forum, go before the magistrates court, then, you know, consumer forum appeal lands up before, in some form or the other, before the state commission, then goes up to the national commission. Privately, if you file a civil suit, that civil suit goes really nowhere. It takes forever. Even, possibly the building will be demolished, but the suit will go on. Then you come up to the high court, and frankly, the lawyers have no clue on what is happening. We all work in different silos. Nobody looks at it from a governance perspective. I think what Namma Bengaluru Foundation, Citizens Action Forum, etc., the action groups have done, and clearly because of the support that they have received from people with integrity and politicians with integrity like Rajeev Chandrasekhar, is that we have culminated this aspect to a matter of good governance. Today, getting a good home at the right price and based on my contract is not just an aspect of private contract of buying and selling homes. It reflects the governance mechanism in this country. When a builder does something, it translates into who is culpable. Is it just the builder? Is it the politician? Is it the bureaucrat? And ultimately, who stands for you? The one thing that the act has done, in my view as a litigator, is that it gives you a perspective that there is one appellate authority before whom you go. If you believe that the real estate authority has not, that the adjudicating authority has not given you justice, you have one appellate authority you go to. That appellate authority is a specialized authority in terms of how real estate is you know, panning out in our system, and from there you straight away come to the High Court. If we as civil society apply our mind and raise these issues before this appellate authority, you will see that significant change, as you have seen in the National Green Tribunal order, which you will hear of. And therefore, I wouldn't want to really deliberate on it now, but once you have seen the presentations, please feel free to raise whatever questions you have in mind. However tangential they may be, do raise it, because I think when answering the questions, we will have more perspective to give you and more anecdotes and similar examples to give you. Thank you.
Thank you so much, Sajan, for spelling out some of the most important facet of the RERA bill, that it cuts through multiple judicial fora that are present today and consolidates the judicial options before a home buyer, before the RERA tribunal and other things. Next, it's my privilege to request Shri Sunil Dutt Yadav to talk to us about some of his experiences in fighting various encroachments, of which he has had a lot of experience. Sunil, over to you.
All dignitaries on the podium and the audience. I look at this act as an addition to the existing law, and it more drives focus to a specialized kind of needs of a certain section of society. With the existing judicial system overburdened, these specialized tribunals lead to easier access to assertion of our rights. So basically, we can look at it as an authority or an institution through which there can be quicker redressal. And the need of the hour today is for the consumer to last the litigation, for which these kinds of legislative interventions are indeed a welcome initiative. Now the interesting part of this legislation is one, it seeks to bring into a mainstream and systematic manner and regulate that which otherwise could have been, was running unregulated. So it seeks to have a centralized system wherein all the developers come into the mainstream. It provides a forum where the adjudication of rights not only as provided under the contract, but rights which the Act itself seems to confer in addition to the contractual rights, can be agitated or asserted through the judicial fora that is provided for. Now, the availability of a specialized fora will not only result in a qualitative granting and understanding of rights and the needs of the consumers who go in to assert their rights, which are of a nature which requires closer attention. The judicial hierarchy that is provided of the authority and then the appellate authority and then the court, one which is fair and just, and it is possible that this hierarchy, the rights at each level can be agitated or find some solution at a quicker pace. The other interesting, two interesting features which appear to strike somebody is one, that 70% of the amount that is collected has to be utilized in effect for that project itself. This is indeed a welcome one which would prevent diversion of funds, and the withdrawal of the 70% also has a number of riders, which appears to be an interesting development. The other few of the other important features is one, there's no limitation, absolutely no limitation to claim compensation. It is indeed interesting wherein you find that after 30 or 40 years, and a litigation is started where the government says that this is lake land, this is government property, etc. And this act provides that the law of limitation will not be a bar for assertion of such rights, which is interesting. The other very interesting aspect is one of insurance of title. According to me, the title scrutiny is done very pathetically by the lawyers from the banks, and generally considering the needs of the consumers. And once title scrutiny passes the strictest test, which would in fact be necessary if there has to be title insurance, it would avoid at least about 60% of the disputes that arise with respect to most of the projects. The other interesting feature is that the developer is strictly bound by the time schedule that is agreed. At the most, years of grace period will be provided for, but there is no provision even under the Act for a relaxing of that beyond 1 year. The power to award compensation is indeed interesting, and in fact, inquiry officers can be appointed for the purpose of assessing the compensatory rights. Now, coming to the last point, is I feel that in all emphasis, this Act seeks to reiterate the necessity for adherence to existing laws. Our system doesn't have a dearth of laws. Upendra Bakshi, a jurist, has said, it's a crisis in the legal system that you need the highest court to say you follow the law. Now we do have laws which says what is the FAR, how it should be built, what are the approvals to be taken, but in effect, if you see how many of them do get the commencement certificate or the occupancy certificate, it's something that with eyes wide open, we turn a blind eye. But this Act seeks to reiterate the necessity that these approvals, etc., have to be adhered to. And in fact, there's a clause which says, till the occupancy certificate is obtained, buildings now, which are in the process of construction, till the occupancy certificate is obtained, will be subject to the Act. If that were so, buildings that may have been completed without an occupancy certificate would be subject to the penalties and the rigors of this law, which is an interesting development. And the last thing I would like to state is, finally, this is a part of the society asserting itself, and this we should see as an incremental effort. And the laws that come over incrementally to improve the levels of adherence to procedures must be, it's a process which is organically progressing and is indeed interesting. The last point, I would just like to say a few words with respect to the NGT order and the position with respect to lakelands. Now, while the NGT order goes a step further of redefining what the buffer zones are, it is indeed an eye-opener that while the courts appear to be stretching the laws towards a much more rigorous requirement in terms of standards, the legislative committee at the state level, which is looking into encroachments of lake, reveals that forget about the buffer zone, which the courts are trying to now enlarge, but the pathetic state in which most of the lakes remain encroached, and now the fight is to regain what is encroached. So the interesting question of the maintenance of buffer zones and whether this judgment would operate retrospectively, prospectively, etc., is one that would churn certain legal issues and concepts, but is a matter of great interest, because one of the directions given is that the environment clearances need to be amended so as to incorporate the requirement of the new buffer zone, which would in a sense result in a retrospective implementation. But nevertheless, it must be remembered that in 2008 there was a government circular which provided the buffer zone would be 30 meters, and now it's enlarged to 75 meters. But there are hundreds of cases that even within the 30-meter zone, there have been private, encroachments. The other angle, which is of legal interest though, is that when a buffer zone is sought to be imposed, the legislature or the courts may need to keep in mind that in case it results in extinguishing certain rights of property of private persons, then a mechanism needs to be involved so as to compensate them, for which there is no other way. In fact, under the Town and Country Planning Act, there are provisions which provide for designation of private properties for public uses such as gardens, etc. And a buffer zone can also be looked at where it may involve the designation of private properties. But the way out of clearing this buffer zone, if it falls within private properties, is either for the government over a period of time to acquire and pay some compensation, which needs to be kept in mind. Thank you.
Thank you, Sunil, for highlighting the provisions, particularly on preventing diversion of funds and the bar on invoking limitation laws to restrict citizens' rights. It is my privilege now to say a few words quickly about Shri Deepak Raj, who partner real estate practice Puvaya & Co., who will be making a very brief presentation on the RERA Act itself. Deepak has represented and advised prominent real estate developers in matters like acquisition of lands, strategic real estate investments, joint ventures, etc. He also has substantial experience in providing advisory services with reference to real estate transactions. I welcome Deepak and request him to make a brief presentation on the RERA Act.
Thank you, sir. Good evening. Generally, in all business sectors, the end consumer is regarded as a king. Especially in the real estate sector, the consumers contribute significantly to the revenues that is being generated in the real estate sector. But then the question would be, if the customer is really treated well or is being taken for a royal ride. Unfortunately, going by the majority cases that we have, yes, it is the customers who are being taken for a royal ride. Now, today we are faced with quality developers, reasonable developers, fly-by-night operators. So we really don't know, whom to go with and how do we assess who is a good developer or who is a bad developer. Now, it is in this context that an enactment has been introduced by the central government, which is known as the Real Estate Regulation and Development Act 2016. Now, the main objectives, like it's been pointed out before by our panelists, to protect the interest of the consumers, to ensure there is a transparency and the real estate sector is is functioning in a very efficient manner. So thereby achieving a sustainable growth, which has been a biggest challenge all this while. I would, if you ask me, I would say this is a landmark reform in the real estate sector. Now, like you all know, Mr. Rajeev has played a very important and key role to bring about this bill and also to ensure that the bill has been enacted without much dilution, although like he pointed out that there were extra pressures and external factors, but he has made sure that this bill comes out without any dilution, and that some of the key features have already been pointed out by the panelists. So now I would like to take you through the enactment, and we have prepared a small presentation just to highlight the key provisions and what the real estate enactment aims to achieve. So let's see the first slide. So like we discussed, why do we need RERA? It aims at real estate, like it pointed out, the real estate sector plays a vital role in India's economy. Now, we all know that there's a great demand for residential and commercial properties, and the home buyers invariably face unscrupulous practice from certain builders and real estate agents. Now, another interesting fact is that, the Act also covers that the real estate agents must be registered and they have to maintain proper books of accounts, which has not been covered by our previous legislation, what the state government has already put in place currently. This is something, a very key factor, I would say, which has not been covered in the past, and now it's been done. Now, like I said in the beginning, most of the real estate dealings are unregulated. They lack uniformity. Now, the reason being that we don't have a proper regulation like what we have now. So moving on to the next slide. So let's see what the RERA promises insofar as the consumers are concerned. Now, it aims at the regulation and promotion of real estate sector, secures the interest of home buyers and removes efficiency from the real estate sector, promotes transparency, governance and accountability, prescribes a strict registration and approval process to establish an adjudicatory mechanism for speedy dispute redressal, achieve sustainable growth in the realty sector. Probably if we had this enactment a few years ago, we would have avoided many litigations, and probably the things would have been fallen in place and we would have had a better practice. But nevertheless, it's never late. We have a good and regulatory enactment in place. So moving on to the next slide. So let's see what are the salient features. It aims to set up a real estate regulatory authority, which the existing Karnataka state enactment does not provide for. Now, like it's been pointed out by the panelists, now any issue with respect to the apartments, so the recourse or the grievance redressal is to go back to the consumer forums or to the civil courts and thereon. And I don't need to explain much about the process. I'm sure most of you have seen how it works. Then it makes registration of certain real estate projects and agents with the authority mandatory. So the reason for this is that, to ensure that all the real estate projects that are being developed in the country are registered with the authority. Therefore, there is a scrutiny before the product is being introduced in the market. It also says that the promoter has to furnish details with respect to the past 5 years project So that itself in the beginning brings about the credibility of the developer. And then promoter is required to execute and register an agreement for sale if more than 10% advance is proposed to be collected. Now, this is an interesting fact. Now, if you see it, the advances are collected arbitrarily. Now, depending on the size of the project, the amenities that the project covers, sometimes you end up paying 10%, sometimes you end up paying 30% and all. So we do have some attractive schemes in the recent past where you don't have to pay upfront advance as well. But to ensure there is a uniformity and to ensure that it is properly regulated, there is a requirement that you enter into an agreement if you are going to pay or if you're going to collect more than 10% of the advance of the apartment. Now then, it mandates the promoters should disclose details of all projects launched by them in the past 5 years, like I pointed out. And the most interesting fact is that the promoters will have to deposit 70% of the project cost in a separate account, which is an escrow account, which will ensure that the advances what you pay to the developer is not being misused and which is being used for what purpose it has been collected. So just moving on to the next slide, responsibility of the promoter. So like I said, there is a creation of which page with relevant details, furnishing documentation to the buyer, obtain the completion certificate or occupancy certificate and make it applicable to the allottees. Obtain approvals before change in layout design. This is another interesting fact if you see. But before we didn't have this concept, although the Karnataka enactment stipulates that you need to obtain prior approval, but that is covered under the Ownership Act, and the Ownership Act is applicable only if you volunteer to submit your project. So, but this mandates that 2/3 approval of the proposed purchasers has to be obtained in case if there is any deviation from what is being represented and for what the sanction plan has been obtained. So, there's another, then the promoter's responsibility is to ensure the association is formed by bringing in all the owners. And the defect liability period has been increased from what the general market practice is for 2 years. Now this enactment makes it 5 years. So moving on to the next slide. So we have various penalties for various violation and deviation from the regulation. So generally it varies from 5% to 10% depending on the offense committed or the deviations that the promoter or the developer is responsible for. So this ensures that this creates a fear in the mind of the developer, especially the fly-by-night operators or the very casual operators, to think twice that whether they should be venturing into a business activity which they are certainly not sure of and keeping up and living up to their promises. So next. So what is the anticipated effect we have? So we have a fast-track dispute resolution through the appellate tribunal, bar on civil courts and cognizance of offences unless specifically permitted by the RERA. It is expected to boost consumer confidence by bringing transparency in the real estate sector. So can we move to the next slide? So ultimately the benefits to the home buyers. So timely delivery. So the regulation ensures that what you sign for is what you get. Now the safeguards, like I pointed out, 70% of the sale receipt has to be locked in a separate account, which will be released only when if certain parameters are fulfilled by the developer, various mechanism again provided in the enactment to safeguard that. So more power to the home buyers, faster dispute resolution mechanism in place, a regulated broker environment, assured 5-year liability period. So I would say it is power packed for the home buyers that, and now it not only covers the apartment, it also covers the layout development and commercial buildings. So if we see what is the benefits to the developer, like now, it's a great opportunity to the developers to contribute to the society, to function in an institutional manner, to ensure that they eliminate their competitor who is not capable of keeping up the fly-by-night operators. So there's an increased scope of eliminating casual operators, potential for driving professionalism in this sector. So the conclusion is that now the central enactment, that is the RERA, has contemplated that authority has to be set up within a year, and the government is required to come up with its own rules, taking into account the local laws. The time period that is given is 6 months, and soon we will have a regulation, that is the rules framed under the act by the state government based on the model rules that will be supplied by the central government. So now I would like to leave it to the panelists and you all to raise question and a debate on the enactment. Thank you very much. Thank you for your patience.
Yeah, thank you so much, Deepak, for highlighting the main features of the RERA Act. 5 years ago, citizens of Koramangala, HSR Layout and Belandur were horrified to find that a 100-acre parcel of wetland opposite to the Agara Lake, which was used to convey freshwater channels to the Belandur Lake, had been taken over by the KIDB and handed over to 2 real estate developers. From that point, almost 5 years ago, several years of struggle in the form of litigation and in various fora took place with the active support of Namma Bengaluru Foundation, and that has resulted in a landmark case ruled on recently by the National Green Tribunal. I would like to quickly request Prashant from Puvaya & Co. to give us a very quick perspective on the NGT order before we start the open panel discussion on RERA. Thank you.
Good evening, everyone. So I'm briefly giving you heads up on the NGT order, which is a landmark judgment with respect to the Bangalore City Lake conservation is concerned and its implication on that. So this particular petition has been presented, as you know very well, as there was haphazardous growth which has led to the uncontrolled development in the Bangalore city. The city has losing its lake to vested interest, and developers are encroaching lake, and also blatant floating of all the rules, inconvenience with these bureaucrats and these government officials. And clearing encroachment is a must to reclaim ecology, that is with respect to the crucial wetland is concerned. This petition has been presented before the, as a public interest litigation before the National Green Tribunal. The application mainly challenged various illegalities in the execution of a large mixed use project coming up in the ecology sensitive areas between Agara and Belandur Lake. That was the main cause of action which was brought before the court. In that, mainly the petitioners were headed by the Namma Bengaluru Foundation, supported by founder trustee, Honorable Member of Parliament, Mr. Rajeev Chandrasekhar, and Forward Foundation, Citizen Action Group, Praja Rag, Bangalore Environmental Trust, with respect to the alleged irregularities, which was the cause of action before the NGT. NGT, after hearing all the concerned parties, and also the affected, the citizens who have been represented before the NGT, it has given a landmark judgment which is now being presented in a slideshow. The verdict basically, if we see, go through that, the principal bench of National Green Tribunal sets a higher threshold of buffer zone around the lake and Rajakalaves. Rajakalaves is that which goes and connects to the lake. Buffer zone around the lake, so it is precisely what the judgment has highlighted is, it increased from existing 30 meters to 75 meters. So Rajakalaves buffer zone to be calculated from the edge of the drain as opposed, this is important, as opposed to the current norm of measuring from the center. Rajakalaves buffer zone increased to 50 meters, 35 meters, 25 meters for primary, secondary and tertiary drains. Earlier it was 30, 25 and 15 meters. So Mantri Tech Zone and Cormine Software Solutions fined rupees 117 crore and 13 crore respectively for the violation which has been found. The NGT order against builders stand testimony to the power of collective citizen action. So now the applicability of the particular the judgment, which is a landmark one. The distance in respect of buffer zone specified in this judgment shall be made applicable to all the projects, and all the authorities concerned are directed to incorporate such conditions in the project to whom environmental clearance and other permissions are now granted, not only around Belandur Lake, Rajakaluves, Agara Lake, but also all other lakes, wetland in the city of Bengaluru is concerned. Other key highlights other than this, which has been just highlighted, the NGT has taken note of water crisis and groundwater scenario in the city. Direction says created sewage water should be used for construction. In case the water is not good enough, the sewage treatment plant should be upgraded immediately. Water source for the purpose of construction must be identified before providing environmental clearance. These are the preconditions to obtain a environmental clearance is concerned. State of Karnataka has been directed to submit a proposal demarcating wetlands for all the lakes within 4 weeks to Ministry of Environmental, which will be officially notified later. These are the directions. So this, now coming to the implication of this NGT order is concerned, a ray of hope for Bangalore lakes. Tribunal redefines the boundaries of lakes and use of treated water for construction purposes. Operative part of the order directs demolition of construction. This is important. The court has taken cognizance of the fact that the wrongdoers must be punished. The demolition of structures violating the new buffer zone, the environmental clearance for all the future projects to have 75-meter buffer zone around lakes as a mandatory condition. Order is in prospective in nature, no doubt. It is judgment likely to affect future development plan for the city. Thank you very much.
Thank you so much, Prashant. At this juncture, we'd like to throw this forum open to the audience for a question answer session. I would request Sajan to moderate the Q&A session as the master of ceremonies for the QA. Sure, Justice Chandrasekhar.
Friends, I would like to give one instance where the Supreme Court came down very heavily upon the destruction of forest. 12/12/1996 is the historic day on which date the Supreme Court protected the forest. In Godavarman Thirumalpad's case, Justice J.S. Verma, the Chief Justice, took over and said it was in respect of an establishment of a sawmill. And even to this day, the case is continuing mandamus are given. Had that order not been passed, by this time, 70% of our forest would have been depleted. Friends, if the courts take, whenever an occasion comes, in respect of this act, if the courts take a very positive step, I think 75% of the work will be done.
Yeah, possibly. Just some housekeeping rules. I'll invite those of you who have questions. Please be very crisp, short, and to the point. If you have more than one question, I would request that you raise one. Let the others raise their questions. I will always come back to you if time permits. Okay, and I hope there are microphones. Okay, can we, if there was a lady asking a question, I would have started with the lady. Now that we have only yes, there is a lady here. Please permit me to start with the lady and then I'll go clockwise.
Thank you. I do have more than one question, but I will just stick to one. Is there any plan on how to promote the information that's in this act? Like, is there any way for us, because many of us probably own houses or we work in real estate or we know something about this, but what about ordinary people who've been saving for generations? They're not very aware of what they're supposed to do. How exactly will they find out even that this act exists?
I'll let Mr. Chandrasekhar take that question.
No, and I think this forum is precisely for that.
Yes.
It is to start creating awareness about what the rights of citizens are. Now, obviously, I can't go to all 7 million Bangaloreans or 1 billion Indians. So that is why I think all of us have a role, including the media, to start talking about what your rights are, not to be helpless anymore. And in this RERA bill, all you need to do is sections 2, 3, 4, and 8. Just read that. Registration, citizen, consumer rights, builder obligations, and penalties. These 4 sections you keep reading, they're very simple. And just make sure people know about it, because your lawyers and your, whoever helps you fight these things, the moment they are aware of this, you are now fighting with not one hand tied behind your back, but you're fighting in a battle that you are designed to win, especially if there is something wrong that is being done. So there's no substitute for awareness creation. There is no substitute for a citizen to being aware of his and her rights. You can't outsource that to somebody. You have to know as a home buyer what your rights are. Now that I can't do for you. You have to know that yourself. And so that is why these forums are there, to make sure you know that you have rights and be aware of those rights.
Apart from this, section 33(3) mandates the real estate regulatory authority to take suitable measures for the promotion of advocacy, creating awareness and imparting training about laws relating to the real estate sector and policies. Therefore, authority must be established as first. They must establish offices ward-wise or zone-wise, and they must create awareness, and they must give publicity in paper, in TV, everything, handbills, everything. It's added to what Mr. Rajeev Chandrasekhar has said. This is a statutory liability, statutory duty of the authority to create awareness.
I'll just add one bit to what fell from the Honorable Member of Parliament and Justice Chandrasekhar. Please understand that the efficacy of an enactment and the efficiency of a regulator is mostly dependent upon the people who will occupy that post. And therefore, it is very easy for a government, a state government, to say some retired bureaucrat who was absolutely useless in his job will now become a regulator. And very clearly, 2 judges who are extremely inefficient in what they did will now become the appellate authority, and that's the end of it. Years of work that have gone in planning this legislation, championing it in Parliament, making it law, will be washed away. Therefore, it is for you, civil society, now start that as a movement, to turn up and say that we need an impeccable person of impeccable reputation to be there as a regulator, and people of impeccable reputation to become appellate authority personnel. That is where your change will be, and that is completely with you.
Absolutely, I second that. That is precisely the point. The enactment is there, the bill is there, but this will be as effective as the regulator is. And if the government does not see that the citizens want this, consumers want this as a right, they will put some non-entity there in the regulator. And we have seen what happens to constitutional institutions when you put people who are either corrupt or lazy or both.
Okay. Yes, madam. I'll come back to you, sir. I'll come in this order.
When you're drafting the law, when you're drafting the proceedings to be submitted before the government, I would like you to please include a few points, that is, the government authorities should be, and the municipal body should be coming under this act, and you should have a single window in which to get all the sanctions. Otherwise, it's going to take a long time. And also define, the builders should define what are the costs. The hidden costs are more than the base costs. Like for instance, they have rental charges and all. Added to that, they say miscellaneous costs, which is more than the actual cost. And I would like you to also add on, as regards the builders, they have buildings with more than a tip without content. They do their design to choose them, to suit them. They should take the what shall I say, the feedback from the end users, how the building should be, what should be when they do the drafting, and abandoned landfills should be used around for parks, and the builders should also go green, and a lot of work has to be done on the legal and financial aspect of the architecture and the legal part of the builders.
Madam, I would request that if you have a particular write-up, do give it to us. We will certainly incorporate it. And I think Mr. Chandrasekhar has something to add.
Yeah, I have quite a lot of points because I've done a lot of homework.
We'll possibly take it.
1 minute, I was the founder member as well as the head of the pilot branch of the Housing Finance Company of Calcutta. and a very proactive resident and welfare association member, also doing a lot of work for people who are buying buildings. Recently we tried to buy a building. The fellow has given full class of the whole building, the builder, and he refuses to change. He says, I want the whole building to be air-conditioned. So there should be some regulation about this also. Thank you.
I just want to make a point. Obviously, I don't have the authority of now to start telling builders what they should do. But here is what the basic concept is. This bill will now start forcing builders to put pressure on reforms in the approval and municipal governance process. This bill cannot do it. What is clearly a state government subject, which is municipal administration, cannot be brought under this bill. So I'm just telling you that you are aware. Second is, this part about what the builder promises you. There is a process of registration. And that process of registration is for the RERA, that is the regulatory authority, to take 30 days to scrutinize what the plans are. And only after the project is registered by the RERA can the builder start selling it. So a consumer knows from the website of the regulatory authority what he or she is buying, because it has been completely scrutinized. There are no miscellaneous charges that will be allowed there. It will be a fixed cost and a fixed delivery period. Only if it is unambiguous will the RERA allow it to be registered. So there is a process, pre-sale process, that is effectively exercising due diligence on behalf of the consumer by the regulatory authority. So that is a very dramatic change in the way business is done today. Apart from that, if there is anything that you want to tell us, please send me that note. I will individually, I'm writing a long letter. I write long letters to the Chief Minister almost every 4 days. Most of them are ignored and filed. But I will write a letter, and I think the idea is, if everybody gets behind what is right for the consumer, governments have no option but to listen. That is the point I'm making. Yes.
Just one quick addition to what the Honorable MP said. Please understand that the structure of this act is such that it ushers in transparency vis-a-vis the builder. So he has to say, you actually get what he says on paper. The minute he does that and breaches it, then the Indian Penal Code steps in. Then it is fraud, it is cheating, it is actually, criminal breach of trust. So therefore, every builder will be very careful in terms of what they say and what they give. There will be some dovetailing. Otherwise, nobody really wants to have criminal action going on in courts. On that point, the gentleman behind.
That is what I'm saying. That is a local government reform that cannot be forced by the parliament. That is something when citizens and builders start saying, no, we can't be spending 80 months and 10 months and 20 months. Governments will have to respond. The BBMP will have to respond. The BDA will have to respond. That is the reform that will be consequent upon this bill being passed and citizens knowing that they have these rights.
So this bill or the amendment, is it going to have power to take action? Because we already have Pollution Control Board, we have Water Board, BBMP. They themselves are fighting among themselves for one or the other reason. In what way this is going to be different? That's number one.
No, yeah.
And the second part of it is, after this stage, when the buyer buys, the builder starts buying it, that time none of the consumer would have been there, because it starts from the 0 point. See, that time only, by that time, because by the time the builders build the thing and plan it out, is there any regulatory minimum requirement which he has to maintain and submit to the authority, so that on behalf of the customer, even before we get in there, that should have been standardized. Some normal set of rules had to be put in place. Then only all the buyers, 200 flats are there. The beginning, all the 200 have not been purchased. So there has to be a minimum set of standards which should be laid down by the authority, which the builder has to put in. Then only the department should accept it and release for further sale or whatever it is, so that everybody gets a minimum of the chunk of their share, that nobody gets deceived or whatever it is going to happen.
No, so let me answer your first question. If you look at Chapter 8 of the Act, it is an act, the chapter is titled Offences and Penalties. That whole chapter deals only with penalties. The difference between the KPSCB and the other authorities that are regulators in the city is that none of those acts talk about citizen rights. Here, the penalties are a consequence of a breach of a consumer right. There it is a regulatory function, and a regulator may or may not be negligent in discharging his function and may or may not do his job, and that is what we are seeing elsewhere. So that is point number one. So penalties are there, it is unambiguous, and it is upon the breach of an obligation or breach of a right. Sorry?
The authority will charge on the penalty.
Charge, there is even going to jail. There is even jail.
3 years punishment.
So please, I would request you, please read chapter 8. You will be very, very happy if you're a home buyer who's been frustrated in the last many years. Yes. The second point I just want to make is, I think you still haven't understood, and that is the point I was making. A builder cannot market his or her project unless he registers that project. And the registration of that project cannot be given unless the regulatory authority scrutinizes his plans, understands he has got a commencement certificate, and all plan approvals required for commencing the project he has already obtained, including transferring the title of land. So there is no uncertainty when the builder starts selling the project to the consumer. The consumer takes no risk. That is the basic principle, that the due diligence that a normal consumer should have been doing, the regulator is now doing for him or her. And that unless a project is registered, the builder can't sell, and unless the builder can't sell, consumers won't buy. Yes, yes, yeah.
Current trend is for any project to start, they have to get the permission to construct, then completion, then deployment in pollution control board. But none of them are there. In spite of all that, we are having this much problem.
No, but there is no legal prohibition from a builder to market the project. He is technically allowed to construct only with a commencement certificate, but he starts selling the project beforehand. That's my point.
Yes, the gentleman.
May I, sir?
1 minute.
Muralidhar Rao, member of Praja Rag, we were very much involved in the, Belandur lake protection, that encroachment into the Belandur floodplains that was going on. And thanks to the help of Rajeev Chandrasekhar, it is now stopped for the while. Okay, matter is in Supreme Court. I expect the Supreme Court will come up with a favorable verdict. That's another matter. And also, we were also fully involved in the drafting of the Real Estate Regulatory Authority bill. Now, just now Sajan had mentioned it is up to the citizens now to make use of this the law, and then further make sure that all the builders conform to the act. Now that is where we have formed another organization we call RERA Karnataka. In fact, Mr. Shankar here was part of the team that went to Delhi. He made about 8 trips to Delhi, camped there to ensure that the bill was passed. Okay, and it's not only from Bangalore, from all across India. Citizens came over and lobbied together to ensure that the bill is passed. And now this Karnataka chapter is already, we have met a number of times. About over 200 members have already joined us. We are formally registering as a society, and then we will be taking up with the Karnataka government to now, the center has done its job. The state government has to now enact enact the bill. The state job has to do it, and we are going to be pursuing that with the state, and also the regulatory authority, the proper regulatory authority. So many of the, those who have not been aware of the goings on, I would request you all to join this RERA Karnataka Google group. It is all there. Many of the questions have already been answered, and please join us in our effort. And I would request Namma Bengaluru Foundation to help us to take up with the government to make the necessary legislations. And also, I have been trying desperately to have a dialogue with CREDI, but they have not been coming forward to do that, and that is unfortunate. Well, we will now force them to do that through this act. That is the whole purpose of it. And so I would all welcome you to join this RERA Karnataka and join us in our effort to speed up the process of enacting the state law and then furthering our action. Thank you.
I would just recommend, I would urge you, apart from notifying RERA, regulatory authority, the interim authority also has to be notified. And my strong, urge, recommendation, begging, whatever you want to call it, is to make sure that you also focus on the quality of the people that are appointed there. What you don't want is, again, builders to capture even that position. They have captured almost all positions in the city. Now, RERA, they should leave to us, to the consumers.
Sir.
I don't think we have the power to propose anything, but I think we should be aware, and I think we should have a view. I think this is where I'm appealing to media as well, that you must have a view on the quality of the person who's a regulator. Just like a good judge, like Justice Chandrasekhar, a good judge makes a big difference in the delivery of justice. Yeah, so it is. So I think the shop. So here is what I would do, and I've done this in the past. First is to put pressure on the government about the criteria and qualifications of the people that they are going to choose. We can have a view on that. Citizens can have a view that it should be a man of integrity. It should be a man of capability. It should be a man who will stand for the citizens. Those things we can say, even if we don't say a name. Second is, if the government does something wrong and appoints somebody, let us say, less than meeting the qualification, we can make it very, very difficult for that person to do the wrong thing. You understand?
Yeah.
One is to select the person who will do the right thing.
Right.
The second option, second side of the coin is to make it very difficult for people to do the wrong thing.
So why don't wait till then?
No.
Why don't we write to the government?
Yeah. That's my exactly my point. You know.
So that is what. So I agree with you, and I said what I said in the beginning was we will write all of this, but I always have a plan B and a plan C, and so I have A, B, and C, and I'm telling you all three plans.
Justice Chandrasekhar had a point.
There is a specific provision, section 22 of the Act. There is a special committee constituted to appoint chairman and members of the regulatory authority. Who should be the chairman? The qualifications are set out. Whenever the Chief Justice is one of the members or a nominee. While selecting such persons, the Supreme Court has laid down clear guidelines in the case of Kannadasan versus State of Tamil Nadu. A retired judge of the High Court was appointed as a chairman of the State Consumer Grievance. It was a public interest litigation was filed against allowed, and his appointment was set aside, and he took up the matter to the Supreme Court, and he begged the Supreme Court to withdraw it. No permission was granted, and ultimately the Supreme Court has laid down guidelines as to the parameters to be kept in mind while making such recommendations. So let us be sure that with such a good body, we hope that good members will be selected.
I just want to if you go to clause 22, I'm just reading it out, I won't read the whole thing. The chairperson and other members of the authority shall be appointed by the appropriate government, which is Karnataka government in our case, on the recommendations of a selection committee consisting of the Chief Justice of the High Court, that is Karnataka High Court, or his nominee, the Secretary of the Department dealing with House and Law Secretary, in such manner as may be prescribed, from amongst persons having adequate knowledge of, professional experience of at least 20 years in case of chairperson, and 15 years in the case of members in urban planning, housing, real estate development, infrastructure, etc., etc., etc. So there is some oversight. It is not being done in some dark room in Vidhan Sabha. There is a Chief Justice of the High Court who's involved, and we have to believe that that process will throw up some men of integrity or women of integrity.
Perfect.
Sir?
Yes, please.
First of all, I would like to thank Mr. Chandrasekhar and...
Yes, sir, I will read them out.
First of all, I would like to thank Mr. Chandrasekhar and Select Committee Chairman specifically for doing a very good job, because this bill, the version that we have in hand, is much better than it was at the earlier occasion. Okay, now coming to the question, I have identified one major flaw in this bill, and I will like to ask one question. Sir, I would like to draw your attention towards clause 11.4 and H. Section 11, the promoter shall, yeah, the promoter shall and H, which says that after he executes, page 13, sir. Yeah, after he executes an agreement for sale for any apartment, plot or building as the case may be, not mortgage or create a charge on such apartment, plot or the building as the case may be, and if at any such mortgage or charge is made or created, then notwithstanding anything contained in any other law for the time being in force, it shall not affect the right and interest of the allottee who has taken or agreed to take such apartment, plot or building as the case may be. Now the issue here is, the builders are mortgaging the property before marketing the project. So they already are mortgaging the land with the banks. So they are taking the loan on that property. Now after that, subsequently the buyer is going and they are taking the loan on that property. Now if the builder defaults its loan, what will happen? No, it can be done. Sir, you read the provision.
1 minute, I think his clarification is this. Please understand that the act cannot improve a factual situation as to what has already occurred. If a developer has already taken a loan on a land, he then has to put those details on a website. You as a purchaser will know that this land is mortgaged even before you book your apartment. If you then book your apartment on a property which is mortgaged, I don't think you as a citizen can then turn up and say, no, it was already mortgaged.
You show me one project in Bangalore.
1 minute, sir. Please answer. Please listen to the answer as well. The act is very clear that you cannot have a situation where post facto your rights are diluted. That once you have with your open eyes registered an agreement, subsequently the builder cannot make your position worse off than what it was at the point of time of. That is the essence of the act. Sir, now in addition to it, if you have a genuine concern where you believe in a particular project there is a problem, please raise it. I am sure NBF and Namma Hakku will sit down and kind of deal with a particular solution for it.
Sir, I will tell you, you go around in Bangalore, you will find out one property where there is not a project loan, okay, and nobody knows about it. As a consumer, you ask anybody who is owning the apartment here, sir, you have a perspective from the builder's thing, sir, you are not looking from the consumer perspective. Not a single consumer will be knowing that that property is already mortgaged, because even in the encumbrance certificate, it is not reflected.
Let me answer. Yeah. There are two basic fundamental principles in this bill, in this act. Point number one is there is full disclosure of the terms and of the project before a builder can register and builder can market. So therefore the consumer knows all of the issues relating to the project, whether the project is mortgaged, land is freehold, it is leasehold, all that he will know. Point number one. Point number two, this bill does, and I am telling you emphatically, does force builders to change the financing model of builders and projects. This bill will force them to change it. No, sir. How?
Sir, that's what the provision is saying. Provision is saying once you are subsequently, but the builder is taking the loan prior to selling the project, prior to market the project.
No.
He'll disclose it.
He will have to disclose it.
Sir, there is a RBI circular I can read out. It clearly says that a disclosure should be there. Not a single builder or not a single bank is disclosing it. This
act is not retrospectively applicable. This act does not apply to any of the projects that have been done so far. It does not attempt to clean up anything in the past. This is for all projects. Let me, for purposes of clarity, this act applies to all projects that will be registered with RERA once the RERA is effective, which is either October 2016 or March 2017. The state government has time till March 2017, but even then interim, by October, they must have a designated authority. So it does not apply to any project in the past, as of yesterday or day before yesterday. One second. Let me explain to you what ongoing, all projects to date that have underway but have not got occupancy certificate and that have not been officially occupied. Let me finish. We can have a discussion. Will have to mandatorily register. I'm repeating again. All projects that have not been handed over to the consumer will have to mandatorily register. Now, when you register, you have to disclose all the terms of the project. And in that register, only after that has been scrutinized by the RERA will it be registered.
I will read out section 5. Yeah, that's a major flaw. That's a major flaw. Sir, please draw your attention towards section 5. Draw, please. See, section 5 says, one second, I will tell you. Sir, section 5, 1 second. Just a minute. Section 5 says, reject the application for reasons to be, section 5, 1b says that reject the application for reasons to be recorded in writing. Such application does not conform to the provisions of this act or the rules or regulation made thereunder. Subsequently, you read section 2, what it says. If the authority fails to grant the registration or reject the application, as the case may be, as provided under subsection 1, the project shall be deemed to have been registered. What does that mean, sir?
Deemed provision adu. It will not happen so easily. Authorities can't keep quiet. See, ಈಗ ನಾವು ಒಂದು ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು ಇವ್ರೆ, ಈಗ ಎಲ್ಲ ನಡೆದಿರೋ ಅನ್ಯಾಯಗಳ ಮುಂದೆ ಆಗಬಾರದು ಅನ್ನೋಕ್ಕೋಸ್ಕರ ಈ ಕಾನೂನು ತಂದಿರೋದು. Please understand, all these cut short methods were adopted by many. I don't want to say everybody. That will be avoided because of that act. Suppose a person carries out the real estate business project without registration, it is an offense.
Sir,
it's an offense.
Sir, statute is saying that automatically there will be a registration even if it will be rejected. Even if they will be rejected, then also there will be a registration. Then what is the meaning of registration?
ಒಂದು ತಿಳ್ಕೊಳ್ಳಿ ಇವ್ರೆ, ಈಗ ಈ ಆಕ್ಟ್ ಬಂದಿದೆ ಕಣ್ರಿ. ಈಗ this act has already come into force. Now you must insist the government to appoint an authority, make rules. ಅದಾದ್ರೆ ಫಂಕ್ಷನಲ್ ಆಗೋಗುತ್ತೆ. ಸಪೋಸ್ ರೂಲ್ಸ್ ಆರ್ ನಾಟ್ ಫ್ರೇಮ್ಡ್ ಎಟ್ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, ಅವಾಗ ಅಂಡರ್ ದಿ ಗೈಸ್ ಆಫ್ ದಟ್ ರೂಲ್ಸ್ ಬೀಯಿಂಗ್ ನಾಟ್ ಫ್ರೇಮ್ಡ್, act will virtually become ineffective. Therefore, the pressure must be on the government to see that rules are framed at the earliest, authority and its members are nominated, and also the appellate tribunal is established in accordance with law. Then ಸಣ್ಣ ಪುಟ್ಟದ ಯಾವುದಾದ್ರೂ ನ್ಯೂನತೆಗಳಿದ್ರೆ ರೂಲ್ಸ್ ನಲ್ಲಿ ಅದನ್ನೆಲ್ಲ ಪ್ರೊವೈಡ್ ಮಾಡ್ಕೋಬಹುದು. ಆಕ್ಟ್ ಗೆ ಏನಾದ್ರು ಅಮೆಂಡ್ಮೆಂಟ್ ಬೇಕು ಅಂತಂದ್ರೆ ಚಂದ್ರಶೇಖರ್ ಇಸ್ ದೇರ್, he will propose certain amendments.
That is what I am trying to tell you. There is a major flaw here. You read, sir.
So look, I am explaining the act as I understand it. If you believe that there is a lacuna in the act, I mean, I am not defending the act. If there is a genuine problem, we will address it. We will address it either in the rules or we will address it through a future amendment.
See, each. No, just.
No, please understand. Regulations cannot be framed unless the authority is established. Within 3 months of the establishment of authority, regulations will have to be made and they will have to be placed before the parliament. Regulations are not yet framed. Rules agilla innuve. Then Allah, please
Let me.
Local government.
Yes, I think you have made your point. I think you are right that please understand that we are in a phase of transition now. The act has just been promulgated. There are regulations to be made under it. Of course, rather than crying after the regulations are made and non-effective or ineffective authorities are appointed as regulators, the whole task of doing something like this as Namma Hakku series is to make sure that we delve into it and there is civil society opinion built so that the right things happen. So we can't expect that this becomes an automatic remedy for all maladies overnight. It certainly won't be. But we should appreciate that this is a very strong step in the right direction, and unless we participate in making it stronger, we can't really expect magical remedies. Now on that point, there's a gentleman here waiting for questions. I have a few questions thereafter which have come to me. I will read this out. Please.
Hello. My question is, landlords generally sign up with builders, and are they treated in this bill as apartment buyers, or are they party to all this regulation along with the promoter? Because if the project is abandoned midway, is the landlord also as liable as the promoter, or is he also a person suffering along with many other buyers?
Joint venture. So I'm a joint
Yes.
venture.
If anybody else is taking it, fine,
yes.
otherwise I'll very quickly answer it. The omnibus provision is very clear. You can't run with the hares and hunt with the hounds at the same time. The act is absolutely clear. If you partake the character of being a landowner, submitting your property for a joint development, you partake the character of a promoter, and there are liabilities on you as well. Therefore, rather than fly-by-night operations happening where somebody's land is taken and with or without his knowledge a development goes on, will not occur. These declarations which are made will indicate the fact whether the developer is the owner of the property. If he is not the owner of the property and it is a third-party property, on what legal basis he is developing it. So automatically the obligations apply.
No, has that answered your question? No. What his point is, he's a landlord. He's giving the land to a developer. The compensation for the sale of the land is some apartments in the project. So he's essentially a buyer. And so therefore, your rights under this act will be as a buyer. If you are in the registration, during the time of registration, if you call yourself the promoter or co-promoter, you will be liable.
Because you are causing to prosper.
Yeah.
No,
So the promoter definition is
yes, the definition of promoter.
a person who constructs or causes to be constructed an independent building or building consisting of apartments, or converts an existing building or part thereto into apartments for the purpose of selling all or some of the apartments to other persons, and includes his assignees. So I am not a lawyer, but you may want to consult lawyers before you sell the land and become a joint developer or a co-promoter. So, I mean, common sense is telling me that the land transaction should be a pure sale transaction, and the buying transaction should be a buying transaction where you are a consumer. I mean, this is my common sense. You may want to say.
Your explanation ಓದಿದ್ರೆ, a person who constructs ಅಂದ್ರೆ on his own or causes to construct ಅಂತಿದೆ. ನಾನು ನಿಮಗೆ ಜಮೀನು ಕೊಟ್ಟು ಕಟ್ಟಿಸಿದ್ರೆ I will be a
You will be a
promoter
promoter.
for all practical purposes, and act will apply with all rigor.
And then it becomes a private dispute between two parties. I have three questions here.
Last one, sir.
We have 15 minutes left. Would you please permit me? I will just read the questions which have come in
Sir,
well
one last-
ahead of time.
sir, one last-
I'll come back to you, sir. There is a question which says, how do we get project insurance by Mr. Nandagopal? I think very quickly, let me answer it. That's a separate issue. I don't think we should keep the entire team waiting for it. Maybe one of the real estate people, the lawyers who are here, will specifically answer that question. Second, Mr. Ananthamurthy has said, is this act applicable even when a project is complete but no completion certificate is obtained? I think Mr. Chandrasekhar has answered that question. Second, there is again a question from Mr. Amaresha on the difference between Rajakaluve, Halla, etc. Even that, please permit us to take it offline. We will get the lawyers to explain. Each of them are a defined expression. But broadly, the NGT order applies to any water body or any causeway in which the water naturally flows. So I don't think people can get away from the definition very easily.
Nodi, I think there is to create an alternate dispute resolution mechanism is obviously better than today. Now, whether that alternate dispute resolution mechanism will also become overloaded, only time will tell. My own view is, my philosophy is the following. If we ensure very simple, strong laws and enforcement and encourage business to be law-abiding, then there will be less and less disputes. That is what we should aim for. Not by creating hundreds of courts and Supreme Courts and super courts. We don't want disputes. We want builders to work in a legal, law-abiding manner. We want consumers to get what they have been promised. Then there will be no dispute. So I am hopeful that the tribunal will have no work, the appellate tribunal will have no work, everybody will live happily ever after because the builders will change their leaf and become good people.
Maybe the last question is. 1 minute, sir. I think you should take the microphone and answer.
Now, we are already having existing Act 1972 by state government. Until RERA Act is passed by state government by amending, it may take say 1 year or 1.5 years, we do not know. Until then, we have to live with the existing Act. Then, in the between the existing Act and the new RERA Act, what are the differences between the title transfer of common area? Then one more question. How the transfer of common area is transferred between this and that present system and next system? Then the association formation is the authority for taking the transfer, the title deed, titles. How is this present? How is the future? So this is my simple question, sir.
Yeah. Let me very quickly attempt to answer it. Please don't be under the impression that because the Real Estate Regulation and Development Act has now been promulgated, our state enactments will fade away. They will not. They will continue to operate on exclusive basis so long as a provision of the State Act is not contradictory to the Central Act. If it is contradictory, the Central Act will prevail. As regards deed of declarations, transfer of ownership to the community, etc., that is the owners association, the existing legislations will continue, but certainly be further buttressed by the fact that RERA now has a provision that yes, the process of devolution must happen in a time-bound manner, failing which there is liability. Earlier there was no liability to the developer. Now there is financial penalties, there can also be imprisonment.
Sir.
For all projects in which you have not obtained occupancy certificate, it will apply.
But consumer is already occupied, sir.
So if you have occupied, then your regular existing court system is what should help you. We are now going towards development, so we can't really cry foul of what has already occurred. The position is that we have a particular system today. We will have an improved system going forward.
But in this case,
Sorry. 1 minute, sir. There's a gentleman here. I'll come back to you. I think these are the last two questions. Permit me to stop thereafter because I don't think we have time. And there's tea and coffee served there. We can have discussions offline even when we are having tea.
Good evening. Sir.
1 minute.
RERA you can only approach if it is a registered project, if it's a RERA registered project. RERA is not a forum for adjudicating disputes for projects that are not RERA registered.
Yes,
sir. My question is the builder mandated to provide OC, and how to ensure it can be endorsed in the agreement, sir? Can I do that?
No, but how to ensure that that is endorsed in the agreements?
Yes, sir.
Under the Act now,
Sir.
the developer is certainly mandated to ensure that all clearances, including completion and occupancy certificate, is obtained. Even assuming your agreement does not contain that clause, today it is a statutory stipulation. So even if the developer has not said so in the agreement, the law will mandate that he does it.
Yes. Because if he doesn't give the OC completion certificate, the liabilities on him continue. He has an inbuilt incentive to get you the completion certificate and get the headache off his head.
Yes, get out the rigors of the Act.
You understand?
yes, sir, there is a delay.
There's an incentive for him to give you the completion and occupancy.
Sir, will the footage of this evening be available on YouTube?
Yes, sir. In continuation, sir. In continuation.
Okay, the last question,
Yes,
gentleman
sir.
in
Sir,
blue.
in continuation is question.
Please.
The OC is not obtained. Okay, but there is a huge delay of like 1 year, 2 year.
Yes.
But consumers will not wait for 1 year, 2 year because they have borrowed the loans from bank. The interest will go up. But consumers have occupied their respective units. Out of 30, 20 is occupied. But in that case, what is the RERA?
Physical occupation of the building is not the test.
Okay.
Whether occupancy certificate is issued is the test.
Okay.
Even though you may have physically occupied the property to protect your rights,
Yeah.
you can still initiate action under RERA.
Under RERA, sir.
Yes.
Thank you, sir.
Yes, of course.
Then you have to get them to
You register it.
all projects today that are not occupied officially have to, by the act, register in RERA. No, it is legally obligatory for the builder to register. नहीं तो he's been in violation of the law. नहीं तो jail जाएगा. He'll go to jail.
Last 11 years I've been fighting for Diamond District. We have met Priya also. I have gone to the court and they have got partial occupancy. Occupancy.
Can I make one request? This is a pendentalized court litigation matter.
Sir, there is a partial occupancy.
No, I think we can take that conversation offline. I don't think the entire group must be burdened. Yeah. Yes, and I can only leave it to Nitin with a request that yes, we have tea, so please wait for formal vote.
Yeah. Thank you. Sorry, we'll have to stop the Q&A right here. I'll just quickly request Rajshekhar, the president of the CF, to propose a formal vote of thanks to the panelists and to everyone in this hall. Rajshekhar.
Those who get scot-free by giving all kinds of illegal sanctions and doing all the wrongdoings, the courts let them off. I think you have changed the trend. I think you should go on that, and all of us will support that. Number two, sir, one more thing, one more point. I would request you, please, whatever we are discussing and about this bill, please give wide publicity. Let all the common people know about it, not only a handful people of us.
Madam, our Sajan Puvaya will be writing a exclusive Kannada article which will be published in 2 days in Vijayawani. He has already acceded to our request. It will be a great step in aid.
Thank you, but not enough. It should go on regularly in all the dailies. Thank you, sir.
ನಾಗರಿಕರ ಮನೆ ತಗೊಳ್ಳೋ ನಾಗರಿಕರೇ ಜಾಗೃತಿಯಾಗಿರಿ.
Just one thing. There is an amendment to the Prevention of Corruption Act that is also being deliberated by the Parliament. I am on that select committee. One of the amendments that we are doing in the Prevention of Corruption Act is exactly this, which is negligence by regulatory authorities towards enforcement of law. That also constitutes corruption. Currently in the POC it is not there. So it will come. That is the direction in which things are going.
ಮನೆ ತಗೊಳ್ಳೋ ನಾಗರಿಕರಿಗೆ ಇದೊಂದು ಜಾಗೃತಿ ಆಗಿರಬೇಕು ಅನ್ನೋ ಒಂದು ಕಾರ್ಯಕ್ರಮ. ಈಗಾಗಲೇ ಸಾಕಷ್ಟು ನಮ್ಮ ಗಣ್ಯರು ಈಗಾಗಲೇ ಸುದೀರ್ಘವಾಗಿ ಈ ಒಂದು ರೇರಾ ಇದ್ರ ಬಗ್ಗೆ ಹೇಳಿದ್ದಾರೆ. ಇವತ್ತು ನಮ್ಮ ಬೆಂಗಳೂರು ಪ್ರತಿಷ್ಠಾನ, ಸಿಟಿಸನ್ ಆಕ್ಷನ್ ಫೋರಮ್, ಸಿವಿಕ್, ಅಪಾರ್ಟ್ಮೆಂಟ್ ಅಡ್ಡ, ಫೆಡರೇಷನ್ ಆಫ್ HSR ಲೇಔಟ್ ಅಸೋಸಿಯೇಷನ್, NERWA ಮತ್ತು ಫೆಡರೇಷನ್ ಆಫ್ ಸಂಜಯ್ ನಗರ್ ಎಲ್ಲರೂ ಕೈ ಜೋಡಿಸಿ ಈ ಒಂದು ಕಾರ್ಯಕ್ರಮವನ್ನು ನಿಮಗೋಸ್ಕರ ಆಯೋಜಿಸಿದ್ದಾರೆ. ಸೊ ಇದು ನಮ್ಮೆಲ್ಲರ ಕರ್ತವ್ಯ. ಈಗ ಯಾರೋ ಕೇಳ್ತಿದ್ರು, ಇದು ಎಲ್ರಿಗೂ ಹೋಗುತ್ತಾ, MP ಅವ್ರು ಮನೆಗೆ ಹೋಗಿ ಇದನ್ನು ಹೇಳೋಕ್ಕಾಗತ್ತಾ? ಖಂಡಿತ ಇಲ್ಲ. ಇದು ನಾವು ಹೇಳಬೇಕು. ನಾಳೆ ಯಾರಾದರೂ ನಮ್ಮ ಸ್ನೇಹಿತರೋ ಇಲ್ಲ ನಮ್ಮ ನೆಂಟರೋ ಮನೆ ತೊಗೊತಾ ಇದ್ದಾರೆ ಅಂತಂದರೆ, ಈ ಥರ ಒಂದಿದೆ, ನೀವು ದಯವಿಟ್ಟು ಅದನ್ನ ರೆಫರ್ ಮಾಡಿ, ನಿಮಗೆ ಒಳ್ಳೇದಾಗುತ್ತೆ ಅನ್ನೋ ಇದನ್ನು ನಾವು ಹೇಳಬೇಕಾಗತ್ತೆ. ಯಾಕಂದರೆ ಇವತ್ತು ನಮ್ಮ ಅದೃಷ್ಟ, ನಾವು ಈ ವರ್ಕ್ಶಾಪಿಗೆ ಬಂದಿದ್ದೀವಿ. ಎಷ್ಟೋ ಜನಕ್ಕೆ ಅದೃಷ್ಟ ಇಲ್ಲ. ಇವತ್ತು ಈ ವರ್ಕ್ಶಾಪಲ್ಲಿ ಏನು ನಡೀತಾ ಇದೆ ಅಂತ ತಿಳ್ಕೊಳ್ಳೋಕ್ಕೆ ಕೆಲವರಿಗೆ ಕಾಳಜಿ ಇಲ್ಲ, ಕೆಲವರಿಗೆ ಅದೃಷ್ಟ ಇಲ್ಲ. ಆದರೆ ಒಂದು ಮಾತ್ರ ನಾನು ಹೇಳಲಿಕ್ಕೆ ಇಷ್ಟಪಡ್ತೀನಿ, ಇದು ರಾಜಕೀಯ ಪ್ರೇರಿತ ಅಲ್ಲ ಅಂತ ನನಗನ್ಸುತ್ತೆ. ಯಾಕೆ ಅಂತಂದರೆ ನಮ್ಮ ಮಾನ್ಯ ರಾಜ್ಯಸಭಾ ಸದಸ್ಯರು ಶ್ರೀ ರಾಜೀವ್ ಚಂದ್ರಶೇಖರ್ ಒಂದು ಮಾತು ಹೇಳಿದ್ರು, ಇನ್ಮೇಲೆ ನಾವು ಭಿಕ್ಷೆ ಬಿಡಬೇಕಾಗಿಲ್ಲ ಜನಪ್ರತಿನಿಧಿಗಳು ಅಂತ. ಯಾವ ಥರ ಒಳ್ಳೆ ಮಾತು ನೋಡಿ ಇದು. ನಾವು ಪ್ರತಿನಿತ್ಯ ಈ ರಾಜಕಾರಣಿಗಳ ಮುಂದೆ ಕೈ ಕಟ್ಕೊಂಡು ನಿಂತ್ಕೊಳ್ಳೋದೇ ಆಗಿದೆ ನಮ್ಮ ಕೆಲಸ. ಆದರೆ ಇವತ್ತು ನಮ್ಮ ಮಾನ್ಯ ರಾಜ್ಯಸಭಾ ಸದಸ್ಯರು ಇವತ್ತು ಈ ಥರ ಒಂದು ಕಾರ್ಯಕ್ರಮ ಸಾಮಾನ್ಯ ಜನರಿಗೆ ಇವತ್ತು ಅವ್ರಿಗೆ ಮಾಡಬೇಕಾಗಿರೋ ಕೆಲಸಗಳು ಬೇಕಾದಷ್ಟಿದೆ. ಇದೇನು ಮಾಡ್ಬೇಕನ್ನೋದೇನಿಲ್ಲ. ನೀವು ಹಾಳಾಗೋಗ್ರಿ, ನಮಗೇನು ನೀವು ಮನೆ ತೊಗೊಂಡು ಹೆಂಗಾದರೂ ಸಾಯ್ರಿ ಅಂತ ಹೇಳ್ಕೊಂಡು ಅವರು ಆರಾಮಾಗಿ ಐಷಾರಾಮಾಗಿ ಕಾರಲ್ಲಿ ಓಡಾಡ್ಕೊಂಡು ಇರ್ಬೋದಿತ್ತು. ಆದರೆ ಒಂದು ಸಾಮಾನ್ಯದ ನಾಗರಿಕನ ತೊಂದರೆಯನ್ನು ಅವರು ಅರ್ಥಕೊಂಡು ಇವತ್ತು ಈ ಒಂದು ವರ್ಕ್ಶಾಪು ಮಾಡಬೇಕು ಅಂತ ಎಲ್ಲ RWAಗಳನ್ನ ಸೇರಿಸ್ಕೊಂಡು ಈ ನಮ್ಮ ನಾಗರಿಕರಿಗೆ ಏನು ಇವತ್ತು ತಿಳಿ ಹೇಳ್ತಾ ಇದ್ದಾರಲ್ಲ, ಅದಕ್ಕೆ ನಾವು ಧನ್ಯವಾದಗಳು ಹೇಳ್ತೀವಿ ಸರ್. ಅದೇ ಥರ ಅಷ್ಟೊಂದು ಕಾಲಾವಕಾಶ ಕೊಟ್ಟು ಸಮಾಧಾನವಾಗಿ ತುಂಬ ಸುದೀರ್ಘವಾಗಿ ಎಲ್ಲ ಪ್ರಶ್ನೆಗಳಿಗೂ ಉತ್ತರ ಕೊಡ್ತಾ ಜಸ್ಟಿಸ್ AV ಚಂದ್ರಶೇಖರ್ ಅವ್ರಿಗೂ ನಮ್ಮ ಧನ್ಯವಾದಗಳು ಸರ್. ಅದೇ ಥರ ನಮ್ಮ ಮಿತ್ರರು ಸಜ್ಜನ್ ಪೂವಯ್ಯ ಅವರಿಗೆ ಧನ್ಯವಾದಗಳು ಹೇಳಿದ್ರೆ ಒಂಥರ ನನಗೆ ನಾಚಿಕೆ. ಯಾಕಂದರೆ ಎಸ್ ಸತಿ ಹೇಳೋಣ ಅವರಿಗೆ ಏನೇನು ಅಂತ ಹೇಳೋಣ. ಒಂಥರ ನಮಗೆ ಒಂದು ಹುಮ್ಮಸ್ಸು ಅವರಿದ್ದರೆ. ಈ ಕಾನೂನಾತ್ಮಕ ಏನು ತೊಂದರೆಗಳಿದೆ ಅದರಲ್ಲಿ ನಾವು ಯಾವತ್ತೂ ಅವರಿಗೆ ಕೇಳಿದಾಗಲೂ ಅವರು ನಮಗೆ ಜವಾಬ್ ಹೇಳೋ ಅಂಥ ವ್ಯಕ್ತಿ. ಹಿರಿಯ ವಕೀಲರು, ಫಾರ್ಮರ್ ಅಡಿಷನಲ್ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಆಗಿದ್ದರೂ ಸಹ ಅವರು ತುಂಬ ಸಾಧಾರಣ ಮನುಷ್ಯ. ಸೊ ಹಾಗಾಗಿ ನೀವೇನು ಯೋಚನೆ ಮಾಡಬೇಕಾಗಿಲ್ಲ. ಅವ್ರ ಫೋನ್ ನಂಬರ್ ಕೊಡ್ತಾರಾ ಕೊಡಲ್ವೋ ಅವ್ರ ಪರವಾಗಿ ನಾನು ಹೇಳ್ತೀನಿ, ಫೋನ್ ನಂಬರ್ ತೊಗೊಳ್ಳಿ, ನಿಮ್ಗೇನಾದರೂ ತೊಂದರೆಗಳಿದ್ರೆ ದಯವಿಟ್ಟು ಕೇಳ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತಾ ಅವ್ರಿಗೂ ಧನ್ಯವಾದಗಳು ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಮತ್ತು ಸುನಿಲ್ ದತ್ ಯಾದವ್ ಅವರು ಹಿರಿಯ ವಕೀಲರು ಮತ್ತು ಪರಿಸರವಾದಿಗಳು, RWAಗಳು, ಅವ್ರಿಗೂ ಸಹ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಬಂದು ಸುದೀರ್ಘವಾಗಿ ಚರ್ಚೆ ಮಾಡಿದ್ದಕ್ಕೆ ಧನ್ಯವಾದಗಳು ಸರ್. ಮತ್ತು ಪ್ರೊಫೆಸರ್ ರಾಜಗೋಪಾಲನ್, ನಾಗರಿಕರ ಹೋರಾಟಗಾರರು, ಇದೆಂಥ ನೋಡಿ ಭಾಗ್ಯ ನಮಗೆ. ಮತ್ತು ಫೆಲೋ IAM ಅಹಮದಾಬಾದ್, ನಿಜವಾಗ್ಲೂ ಅವ್ರಿಗೂ ಧನ್ಯವಾದಗಳು ಸರ್. ಹಾಗೆ ಇಲ್ಲಿ ಬಂದಿರೋ ಅಂಥ ಪ್ರತಿಯೊಂದು ನಾಗರಿಕರಿಗೆ ತಮ್ಮ ಒಂದು ಸಮಯವನ್ನು ಬದಿಗಿಟ್ಟು ಇದು ನಮಗೆ ಮುಖ್ಯ ಅಂತ ಹೇಳಿ ನೀವು ಬಂದಿದ್ದೀರಾ. ಸೊ ಅದಕ್ಕೆ ತಮಗೂ ಎಲ್ರಿಗೂ ನಮ್ಮೆಲ್ಲ ಅಸೋಸಿಯೇಷನ್ಗಳ ಪರವಾಗಿ ಧನ್ಯವಾದಗಳನ್ನ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಮತ್ತು ಪ್ರಿಂಟ್ ಮೀಡಿಯಾ ಮತ್ತು ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಮೀಡಿಯಾ ತಾವು ತುಂಬ ಕೆಲಸ ಮಾಡೋದಿದೆ. ಇದನ್ನು ಇನ್ನೂ ಸಾವಿರಾರು ಜನ, ಲಕ್ಷಾಂತರ ಜನಕ್ಕೆ ಇದ್ರ ಬಗ್ಗೆ ತಾವು ಸಂದೇಶವನ್ನು ರವಾನಾ ಮಾಡಬೇಕಾಗಿದೆ. ಸೊ ಅದನ್ನು ಮಾಡ್ತೀರಾ ಅಂತ ಒಂದು ನಂಬಿಕೆ ಇದೆ. ತಾವು ಬಂದಿರೋದಕ್ಕೆ ತಮಗೂ ಧನ್ಯವಾದಗಳನ್ನ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಮತ್ತು ಈ ಒಂದು ಕಾರ್ಯಕ್ರಮ ಇವತ್ತು ವರ್ಕ್ಶಾಪ್ ಏನು ನಡೀತು ಅದು ಸಾವಿರಾರು ಜನ ನೋಡ್ತಾ ಇದ್ದಾರೆ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಮುಖಾಂತರ. ಸೊ ಅವ್ರಿಗೂ ಸಹ ನಾನು ಧನ್ಯವಾದಗಳು ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಯಾಕಂದರೆ ಎಲ್ಲೋ ಇರ್ತಾರೆ, ಎಲ್ಲೋ ಬಂದು ಮನೆಗಳು ತೊಗೊತಾರೆ, ಅವರಿಗೆ ಈ ಥರ ಒಂದು ವೇದಿಕೆ, ಒಂದು ಈ ಒಂದು ಏನು RERA ವರ್ಕ್ಶಾಪ್ ಒಂದಿದೆ, ಅದರಿಂದ ಅವ್ರಿಗೂ ಒಂದು ಒಳ್ಳೆಯದಾಗುತ್ತೆ ಅಂತ ಹೇಳ್ತಾ ಇವತ್ತು ನಿಜವಾಗ್ಲೂ ಒಂದು ಸಂತೋಷ ತಂದಿದೆ ನಮ್ಮೆಲ್ರಿಗೂ. ಅದೇ ಥರ ನಮ್ಮ ನಿತಿನ್ ಅವ್ರಿಗೆ ಧನ್ಯವಾದಗಳು ಹೇಳಬೇಕಾಗಿಲ್ಲ. ಯಾಕಂದರೆ ಈಗ ಅದೇ ಹೇಳಿದ್ನಲ್ಲ, ಈಗ ಅವರೆಲ್ಲ ಒಂಥರ ನಮ್ಮ ಒಂದು ಜತೆಗಾರರಾಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. NGTಗೆ ಅವರು ಸಹ ನಾನಾ ಜನ ಅವ್ರ ಜೊತೆ ಸೇರಿ ಈ ಒಂದು NGT ಆರ್ಡರ್ ಬರೋದಕ್ಕೆ ಕಾರಣಕರ್ತರಾಗಿದ್ದಾರೆ. ಅದನ್ನು ಹೇಳ್ತಾ ಶುಭ ಸಂಜೆ, ಧನ್ಯವಾದಗಳು ಸರ್ ಎಲ್ರಿಗೂ. ಕಾಫಿ, ಟೀ, ತಿಂಡಿ ಇದೆಯಾ ಸರ್? ತಿಂಡಿ
Yeah, I've just been asked to say that if anyone has any further questions or discussions, the panelists, while they're having coffee and tea, over a cup of tea and coffee, yes, chai pe charcha, as they say, you're welcome to join. Thank you so much.
ಅದೇ ಥರ ಮಾನ್ಯ ರಾಜ್ಯಸಭಾ ಸದಸ್ಯರಿಗೆ ಇನ್ನೊಂದು ಕೊನೆ ಪ್ರಶ್ನೆ ನನ್ನ ಕಡೆಯಿಂದ, ಸಿಟಿಸನ್ ಆಕ್ಷನ್ ಫೋರಂ ಕಡೆಯಿಂದ, ದಯವಿಟ್ಟು ಈ ಥರ ಒಂದು ಕಾರ್ಯಕ್ರಮಗಳು ಇನ್ನೂ ಹೆಚ್ಚೆಚ್ಚಾಗಿ ನಮ್ಮ ಸಿಟಿಯಲ್ಲಿ ಮಾಡಿ, ಇನ್ನೂ ನಮ್ಮ ಸಾರ್ವಜನಿಕರಿಗೆ ದಿನನಿತ್ಯ ತೊಂದರೆಗಳು ಏನಿರ್ತವೆ ಅದ್ರ ಬಗ್ಗೆನೂ ಸ್ವಲ್ಪ ಕಾಳಜಿ ವಹಿಸಿ ಇನ್ನೂ ಈ ಥರ ನಿಟ್ಟಿನಲ್ಲಿ ನಮ್ಮ ಹಕ್ಕು ಅಡಿಯಲ್ಲಿ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.